We call a meeting to order of the Texas Real Estate Commission at 10:08 on April the 28th, 2014, and welcome everybody to our meeting, and ask everyone to rise, and Commissioner Arriaga will lead us in the pledges of allegiance.
Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Texas flag. I honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you, Commissioner Arriaga. I have a motion, entertain a motion to excuse the absences of commissioners.
Madam Chairman, I move that the absences of Weston Martinez, T.J. Turner, and Chart Westcott for the April 28th, 2014 Commission meeting are hereby excused.
I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Okay. I'd like to reappoint the following individuals to serve on the Broker Responsibility Working Group through January the 31st, 2016. Bill Bradshaw, Jan Fight Miller, Emily Petty, Tom Branch, Helen Perry, Mark Woodruff, Valerie Lyday, Bobby McQueen, Dennis DeWine, Charles McClure, Kathy Schroeder, Bob Guerin, and Scott Kessner. So that would be done. Now we will look to reports by staff, administrator, and general counsel. Are you first up, Mr. Olmixon?
Good morning. Oh, it's working well. Good. Thank you all for your continued service to Texas as members of this important policy-making body. It is spring, and that always means serious work for the agency. In addition to strategic planning, rule review, finalizing the State Auditor's Office audit, and preparing for the internal audit, and working on the first draft of the annual budget for FY15, all topics which you will consider on your agenda today. We participated in the Arello mid-year meeting and in the Texas Real Estate Teachers Association annual meeting this month. Each provides an important forum for us to share ideas for regulatory effectiveness and to advance our specific achievements. We also met with the Government Affairs Committee of TAR to share some preliminary comments generated by the Strategic Plan Listening Tour and to hear their ideas for potential action in the new year. We note today the absence of Christine Anderson, our Public Affairs Specialist, from today's meeting. On Sunday, April the 13th, her baby decided to make an unexpected appearance 6 weeks early. Christine, Parker, and a new son, Jackson, are all doing well, and we have every reason to believe that that will continue. We expect to see Christine back on the job again by your next meeting in August. We filed a quarterly report with the Senate Business and Commerce Committee and copied each of you on that. Agency staff completed the UT-sponsored survey of staff engagement, and as promised at the last meeting, we provided that final report to you and to the entire team on February 28th. We proudly noted that all areas surveyed showed improvement and encouraged continued improvement, especially in our technology. We provided strong staff support to the Education Standards Advisory Committee and the Broker Responsibility Working Group, which both met in March, and each continues to make steady progress on behalf of this commission. At your last meeting, you approved the staff recommendation to engage Pearson VUE as our new exam provider commencing in September of this year, and a series of coordinating meetings has begun and will continue through the summer to ensure a smooth transition from PSI, which has served the agency in this capacity for the past 10 years. And speaking of transitions, Pat Holder, Sandy Jones, Debbie Orozco, and Mary Murphy have all retired since the 1st of March. Each was a long-time respected member of your staff team. We wish them well as they transition to a new stage of life, and we look forward to the energy of each new team member we welcome to replace them. I'm happy to answer any questions you may have of me. Otherwise, I will turn it over to your senior team of division directors for their regular staff progress reports.
Any questions?
Thank you.
Thank you, Mr. Olmixon. Lori DeAnda. Customer service.
Good morning, Lori DeAnda, Director of Reception and Communication Services. If you'll please refer to the C1 report. For the month of March, we received a total of 15,816 calls. We assisted 377 walk-ins and responded to 5,368 emails, and we are maintaining the 2 business day turnaround. And that concludes my report, and I'm available to answer any questions.
Are there any questions for Ms. DeAnda? Thank you.
Thank you.
Ms. Jackson.
Good morning.
Good morning.
Gwen Jackson, Director of Education and Licensing Services. I'd like to take a couple of moments to introduce to you a couple of new team members in the ELS division. First of all, we've got Stacy Cathy. She was recently hired as one of our licensing permit specialists. She comes to us with over 10 years of experience in office administrative positions, and here at TREC, her position specializes in the inspector program and its many intricacies. Stacy?
Stand up.
We also have Jenny Fred. Jenny was recently hired as an education specialist. She used to be employed as a legal assistant with the Texas Commission on Environmental Quality, and she's recently relocated back to Austin, and we've hired her to specialize in the core education program. Jenny? Now, if please direct your attention to the L1 report. The L1 report is the fiscal year comparison of applications received, licenses issued, and renewal activity. Most noteworthy on this report is the fact that we continue to see an increase in sales original applications received. They're at almost 89%, which contributes to the over 72% increase in total original applications from March of 2013. So we're seeing an increase, continue to see an increase in sales applications. You'll also note that our renewal activity is remaining steady. Over 83.5% of those who are eligible to renew actually renew their licenses. If there are no questions on the L1 report, I'll move to the L2 report. The L2 report shows the total licensee and registrant status. We currently have a total of 101,719 salespersons compared to the 94,922 we had last year, March. Now, this is an increase of over 6,700. We also have more active salespersons this year. 76,961 compared to 70,238 from last year. Total brokers and salespersons are at 146,558 compared to 139,869 from last year. Inspector totals are slightly up, and ERW registrations are slightly lower. Last year, we had a total of 145,148 licensees and registrants, and we've increased that amount by 6,447 for a current total of 151,595. If no questions there, we move to the L3 report. This provides our examination activity for the month of March as well as year-to-date results. We've also provided a new report, which is the report following that. It's the L3 report, and this gives us a fiscal year-to-date comparison of the real estate examination activity. If you look at the L3A report, you'll see that the first attempt pass rates for 2013 and 2014 are comparable. You'll see that the first attempt pass rate for salespersons this year was 59%. For 2013, it was almost 59%, 58.9. The first attempt pass rate for brokers this year is at 51.7, and for 2013, it was at 51.9. If you'll draw your attention to the L4 report, this is the total number of approved instructors, and we currently have 4,637 as of March of this year.
Are there any questions for Ms. Jackson?
I noticed that.
Troy, in the microphone.
I always forget this. Okay. Yes, on the number of instructors, just curious, and I don't know if you would be able to give any kind of input on this, but the decrease there, is that significant in terms of why? Or?
Well, the primary reason for that decrease, I think if you'll notice, is for the MCE elective only category.
Oh, okay.
It was 2,738 in March of last year. This year it's down to 2,292. And that could possibly be, in January of 2013, we did increase the application fee for instructors. I don't know if you'll recall, but prior to that time, it was $25 for a 5-year approval period. The current fee is $150 for a 2-year approval period. And so I'm thinking that a lot of the MCE elective instructors, because those courses are not our legal update and ethics, they aren't the mandatory courses, that they feel it's probably not worth their while to renew those licenses.
Okay. Good. Thank you.
Any other questions for Ms. Jackson? Thanks. Thank you. Mr. Moore?
Mark Moore, Director of Standards and Enforcement Services. I've got 3 reports for you today, but first I wanted to introduce one new employee, Brenda Kazee. Brenda has over 20 years of state government experience, including 2 years with me at the Comptroller of Public Accounts. We're very happy to have her. She started on March 17th. We're going to keep her very busy with all these cases. And thank you, Brenda. The first report is the case status report. It has mixed news. We're closing more cases than we opened until March, when we had a huge number of new cases of 231. Since this report's been in this present form, that's the highest by far. The previous high was fiscal year 2011, about 209 cases. The reason why it's so high is if you look at application investigation, that's at 82, which is also the biggest number by far. We're averaging about 45 application investigations per month right now. This, as Ms. Jackson noted in her report, is probably because of the huge number of applications. You're going to have a lot of fingerprints that hit and a lot of investigations that come as a result of that. So that will probably continue, but the good news on applications, if we move to the next report, please. The good news on applications is those usually move pretty quickly. 60 to 90 days is somewhat normal, and then even if they get assigned to a lawyer, those usually move relatively quickly. So this report has good news. We have no cases over 30 months, and for the first time here this fiscal year is we have over 90% of the cases are less than a year old. So this report is mostly good news. The third report is the complaint subject categories report, which is, of course, the pie chart, which shows some of the general themes of cases. Do y'all have any questions on any of these 3 reports?
Any questions for Mr. Moore? Thank you, Mr. Moore. Mr. Watson?
Good morning. Tom Watson, Director of Information and Technology Services. If you could turn to page I-1. Just a quick comment regarding the report on I-1, and that is towards the online transactions. For the initial applications, which is the first grouping under online transactions, we are seeing a really strong demand for the online services in comparison to those transactions last year. Very positive sign, and the trend has continued throughout this fiscal year, which is positive. The renewals also, although last year we were at 90% utilization of the online services for renewals, we're seeing strong demand there as well. We up to 94%. So although that's only a 3% increase, it was already at a very high level. Very positive, as well as finally the sponsorship transactions. Putting that online, we're seeing really good adoption and utilization of that particular service at 85% of all sponsorship transactions coming through the online transactions. So overall, I would say we're seeing really good utilization from the licensees out there for those services being provided. The next page, on page I-2, don't have any comments on that, but it is just a graphical trend presentation of those exact same numbers. I would like to also spend a minute here and talk about a security test which was implemented late last year. We finally got the reports from the Department of Information Services. Every year they come and they try to do a security test regarding our network. And they have two objectives in that test. The first objective is to try to establish control of resources such as your network and to exploit, control of network devices, services, and the web. So that's the first objective. Can they take control of those devices within our infrastructure? The second objective that they have is, can they obtain data? Can they obtain actually information residing on our network and then make use of that information? So this year when they did the test, they failed on both accounts. So we were able to successfully prevent them from achieving either of those objectives. This is, I believe, the third year in a row that they have not been able to achieve those objectives. They did have a number of recommendations, however, on things that we could implement, things to look for, and things to potentially address to actually improve our network security position. So we'll be taking a look at their recommendations and seeing how we can take advantage of some of those within our website as well as infrastructure. So with that, I'll be happy to answer any questions you may have.
Any questions? Yes, Commissioner Arriaga.
Did I remember correctly? We had a problem with hacking a couple of meetings ago. Is that right? Someone tried to get into a system?
No, I believe that what we occasionally see is automated bots which try to scan our website and obtain information through like the licensee search or other means. That is not necessarily, although it could be, it's not necessarily destructive in nature or an attempt to gain access. It's oftentimes a method to just harvest the data that we present so that they can use it for whatever purpose.
We don't have anything of value, do we, except just personal information?
We have most of our information, 95%, is available for open records. So Social Security number, and Carrie, you may have to help me. Social Security numbers, I think driver's license are the only elements that are prevented or not disclosable under open records.
Thank you.
Credit card, but we don't actually, credit card information we don't actually obtain or keep a record of on our site. So we don't have that.
Any other questions? Thank you, Mr. Watson. Ms. Whitter?
Thank you.
Good morning. I'm Melissa Huerta, Director of Staff and Support Services, and the first report that I have for you is the S1 report, which is the budget status report as of March 2014. And if you look on the report, overall, our expenditures are 4% under where we projected we would be at this time of the year. And the only two items that I wanted to bring to your attention are the office rent and the SWICAP cost allocation plan payment. We have paid our office rent for the year, and if you'll notice, it shows that we have 50% left remaining to pay, but we won't be paying that because we did pay that through the SWICAP payment. So when we made our SWICAP payment included expenditures that were allocated to this building, and as part of our lease, those costs are offset against our rent. So we've paid our rent in full, and we're actually due a refund of about $3,000. And so you'll see the SWICAP payment is 120% higher than what we thought it would be because we didn't anticipate these costs last year when we did the budget. Okay. Does anybody have any questions on any of the other items?
Mr. Ariano?
Yes. On the transition from PSI to Pearson View,
Yes, sir.
the objective was not to save money or make money, but how is the transition coming?
The transition to PSI?
In dollars, right?
The dollars that we're going to collect from Pearson View are going to be $10 per exam, where they were $5 per exam from PSI. So on our budget for 2015, because we're not collecting those until 2015, they're reflected in that revenue budget there, the increase in the revenues.
So not till next year.
Right, yes, sir, because PSI is our exam provider until the end of August.
Got it. Thank you.
You're welcome.
And Commissioner, one other thing on the fees that will be charged to the persons taking the exam, in every category, those will be lower.
Okay. The next report is the S2 report, and this is the Real Estate Recovery Trust Account. And in this report, you can see that our ending balance after reserves of $622,000 is $1,189,000. So we have cash balance of $401,000. I'm looking at my report here. And our investment balance is $401,957, and our cash balance is $1,410,000. So that gives us a portfolio balance of $1.8 million. And then less the that money that's set aside for potential payments. Does anybody have a question? Okay. The next report is the S3 report, and this is a report on the Real Estate Recovery Trust Account investment payments and repayments that have been made. So you can see that the payments to date for for this year, for March, are $43,000, and that was for one claim. The total for 2014 so far is $241,000. Does anybody have any questions?
Yes.
Yes, sir.
All payments that we make, we have seen, is that correct? Because I know that we talk about that.
Yes, sir.
We do see all payments before they're done?
Before they're made, yes. We received, when we receive the claim, it's a claim that's already been approved by the commission.
Oh, yes, okay.
Yes, sir.
So never have we approved any payments, or any payments that we have not approved?
No, sir.
Okay, thank you.
Okay. The next report is the S4 report, and that's the real estate inspection recovery account. And in this account, we haven't made any payments this year. We made no payments last year. We do have $8,000 reserved for payments within the next 90 days. And we had our last investment that matured in March. So I went ahead and we did a reinvestment of a little over $500,000 because we're not using these monies to make any payouts. So we want to invest those monies, and then realizing that anything over $600,000 will be going to the general revenue fund at the end of the year. So our balance is $600,000 right now, and that's less the $8,000 that's in reserves.
Okay.
Anybody have any questions?
Do you have something, Ms. Lewis?
Yeah. Is this on? Is this on?
Yes.
Okay. Mr. Arriaga, I just wanted to make one correction. If the commission decides that there's a case, a recovery fund case that we don't think is eligible under the fund, and we send it to the Attorney General's office to fight it, but the judge orders against us and says we have to pay it, that would not necessarily come before the commission for approval.
A second time. It wouldn't come back again.
Right.
So how would we know what's being paid or not paid, or is going to be get paid or not get paid?
Well, if the judge orders us to pay it, and so it will show up on your schedule.
Is it possible
every
to
month?
get some kind of notice saying, hey, guys, we've been overridden and we have to pay this? I try and track what's going on, but sometimes I forget, and sometimes I wonder whether all the numbers that we have approved, I know some are subject to the staff negotiating.
Right.
I would like to be informed anytime we make a payment, if that's okay.
We could do that. We could do maybe at the, when we're talking about pending litigation and other things in executive session, we could let you know the status of any of those cases.
It's not more than 10%.
I wouldn't think so.
Oh, no, far less than that. We could also, similar to what we do with orders, today, whenever we approve a payment, we could simply copy all of the commissioners individually and let you know that. That way you can keep your own running tally if you'd like.
I would like to know.
Okay.
Thank you.
Let's do that.
Also, you did notice that agenda item 30 is to discuss the recovery fund, so we'll have a deeper discussion about that a little later on today. Thank you, Ms. Huerta. Before we move to agenda item 5 and ask for the Budget Committee's report, I just tell you, Commissioners, we're going to move agenda item 29, the auditor's report, between agenda item 8 and 9, so it'd be 8B or whatever you want to call it. And then to remind all of our visitors in the room, if you wish to speak on a particular agenda item, please fill out one of these forms and hand it to Ms. Hinton here in the lovely aqua blouse. And I would remind all of you who plan to speak that you will be limited to 3 minutes, and we appreciate it if you don't repeat that which someone else might have said just before you. So, and I will be keeping time on that. Is this budget report from Mr. Alley? Commissioner Alley or Commissioner Hensley? All right.
Yes, thank you. The Budget Committee met this morning at 8:30, Mr. Alley and myself and Mr. O'Mixon, and we thoroughly went over what the staff provided in regards to the budget for this next year. And we're very pleased in all of the detailed discussions of any questions that we had. And I think there are a couple areas that Mr. O'Mixon will elaborate on when he comes up and gives the report later.
Any questions for Chairman Hensley?
Do we, and I'm sorry I didn't see the budget in detail, did we give anything back to the general fund for the state of Texas? And if we did, how much?
We annually contribute $750,000 prior to August 31st of each fiscal year. We generally try to do that as late in August as possible.
Versus what we used to do when we were IE independent, how much was that?
Prior to achieving SDSI status, all revenues collected by the agency and not appropriated back to the agency by the legislature were returned to the general revenue, and that it generally exceeded $1 million, and sometimes substantially exceeded $1 million every year.
Thank you so much.
Any other questions for Chairman Hensley? Okay. Are you doing the broker sec? Ms. Lewis?
Good morning, Carrie Lewis, General Counsel. I am going to be giving the ESAC report on behalf of Chair Susan Jones, who could not be here today. She wanted me to relay the following information to you. The Education Standards Advisory Committee met on April 7th for another very productive meeting. Many stakeholders were present at the meeting, and their input was much appreciated by the committee. The committee received no comments on the proposed amendments to Section 535.62 and 64 regarding the real estate finance course, and recommends that the Commission adopt those amendments as proposed. In conjunction with the Commission's quadrennial rule review and policy direction previously offered by the Education Standards Advisory Committee, staff presented reorganized and updated education rules for review and input by the committee. The proposed rules reorganize the existing rules to better reflect Commission policies and approval processes for providers, courses, and instructors, and to clarify terminology and simplify text for greater understanding. Most of the proposed rules contain the same requirements as the current rules, although based on policy input from the committee and procedural issues raised by TREC staff, there were some substantive changes. The committee is not finished reviewing these proposals, but anticipates bringing a recommendation on the proposed rules to the Commission at their August meeting. Some of the major issues the committee discussed and will continue to study are whether to allow courses to continue to be delivered by correspondence, and if so, how to ensure adherence to the accreditation standards of the college or university. After a lengthy discussion at the meeting, the committee is considering allowing correspondence courses to remain to be provided in associated with an accredited college or university if that course can be certified by a distance learning certification center acceptable to the Commission. IDEC, a Commission-approved certification center for online courses, does not certify correspondence courses due to the difficulty of implementing and regulating standards for correspondence courses. Another certification center that does certify correspondence courses was suggested to the committee, and we have requested staff to review the standards used by that entity. Another alternative would be to have the university or accreditation body for the university certify that the correspondence course was being offered in accordance with the standards for that university. The current standard, this is the current standard in our rules today. However, it's the provider who certifies that those standards are met. Staff is also looking into the viability of this option as well as ways to increase auditing and enforcement of those standards. Two other major issues of discussion at that meeting were eliminating the exemption from becoming a core provider for real estate trade associations. Trade associations are already required to become a provider for continuing education. And then the last major item of discussion was requiring all instructors of core courses and non-elective continuing education courses to take an adult education instructor training course approved by the Commission, and then developing a more robust instructor evaluation system. The next ESAC meeting is set for July 8th at 10 a.m. At that meeting, they'll continue to look at the proposed rules for core and continuing education, look at allowable credit for continuing education, and discuss whether broker responsibility course that's being developed should be required of all brokers and whether it should be delivered via classroom only. And then, of course, make recommendations on any proposed education-related strategic planning items that may be presented. And Ms. Jones wanted me to remind all stakeholders that she appreciates and values their continued participation in the process.
Thank you, Ms. Jones, a.k.a. Lewis. Are there any
now
questions?
I'll make my
Now
voice
you're going to
deeper,
become-
and I'll do the report for Chair Mac McClure for the Broker Responsibility Working Group.
Thank you.
Okay. The Broker Responsibility Working Group held a meeting on March 25th. The group analyzed the experience requirements to qualify for a broker's license and the current point system used to evidence that experience. After lengthy discussions addressing the point value and fairness concerns in relation to commercial transactions and property management and other miscellaneous transactions, the group proposed several revisions to the point system. The group also discussed the audit process for experience claimed and recommended that applications include a log identifying the properties for which points are claimed. The group did not feel this would be an undue burden since most licensees keep or have easy access to those records currently. The recommended revisions to that rule and application forms will be presented to the Commission at their August meeting when the other education and qualification rule amendments are presented. An update was given by me as General Counsel regarding the second edition of the required broker responsibility continuing education course that's being developed, and the group liked the proposed redesign that will track Rule 535.2 on broker responsibility and will be more interactive. The group also discussed errors and omissions insurance requirements for a licensed business entity owned by multiple licensed business entities that already have E&O insurance. The concern was that an additional errors and omissions policy should not be required by the parent entity. After discussion, staff pointed out that there are rules in place to deal with this scenario already, as long as each of the owner entities own more than 10% of that parent entity. Additionally, many errors and omissions insurers will cover additional licensees at a low additional cost, and so no action was taken by the group or recommendation from the group is coming forward from that discussion. The next meeting of the group will be held in August, where the focus will be on ways to continue to strengthen broker supervision and responsibility. Some of the items to be considered are formulating a required realty chain of command disclosure form. They'll bring that to you in August. Reviewing the minimum services requirements for brokers and increasing continuing education requirements for brokers. So those are on their agenda to consider and possibly bring recommendations forward. And I think their next meeting is going to be, they haven't set a date yet, but it's going to be early August.
You have a question, Commissioner Jones? Oh, that was she just answered. Thank you, Mr. McClure, a.k.a. Miss Lewis. And now I look for Chairman Murphy. You have a inspector committee? Agenda item 8.
Good morning, everybody. Brian Murphy, Chair of the Inspectors Advisory Committee. We met this past April 14th. We addressed several things from the education inspection report forms and also making some finalizing some recommendations on changes, some small clerical changes to the plumbing portion. Short of that, we don't have anything big coming up. We're not making any recommendations, or we are making some recommendations for your agenda items 13 through 16 today, and I'll be available for any type of questions that may arise from those. Any questions for me?
Any questions for Chairman Murphy? Thank you and your committee for your work. And now we have moved agenda item 29 to this place, and so I would ask if there's someone here that would like to present the internal audit report.
Good morning, Madam Chair, Commissioners, Mr. Administrator. My name is Richard Galindo. I'm an audit manager with Garza Gonzalez and Associates, and we want to thank you for allowing us to present the enclosed proposed fiscal year 2014 internal audit plan for the Texas Real Estate Commission. We understand that you've been provided a copy of the proposed plan, and this plan determines the scope of internal audit activities and is the source for assignment and prioritization of the internal audit responsibilities for fiscal year 2014. The planning process is a naturally ongoing process, and the plan is reviewed annually and may be revised as necessary by the Commissioners. The plan has been prepared following generally accepted auditing standards and the international standards for the professional practice of internal auditing as determined by the Institute of Internal Auditors. The preparation of the plan was based on a risk assessment where we reviewed various documents and conducted interviews and with various employees as documented. The documents reviewed including organizational charts, operating budgets, financial reports, policies and procedures, etc. We performed interviews with the executive director, division directors, and other staff in order to update our understanding of each division within the overall process at Texas Real Estate Commission. We identified 18 audit areas as potential audit topics using this risk analysis. The internal audit plan on page 4 includes 3 audits to be performed during the fiscal year 2014 and includes a follow-up of prior year audit recommendations which were deemed not to be fully implemented. The 3 areas we're recommending are the education program monitoring, recovery fund, and timeshare registration. Does anyone have any questions?
Any questions for Mr. Galindo at this point in time?
I do.
Commissioner Arriaga?
Mr. Galindo.
Yes, sir.
On the high risk, I don't understand the page 326 of 358, the chart that you have.
The chart?
Yes, sir.
Okay.
And if we look at examination process, I've always been very concerned, critical that the examination process is compromised, but we have no proof, but except what you hear back home, that people sometimes don't take the exam, but they still pass it. And I know we have our checks and balances, but I cannot prove that. Walk me through the process of the point system on number 2, examination process. See if I can understand it.
We did rate it as a high-risk area, but our understanding was that there had been a review a process, an RFP process, and that the Real Estate Commission would be selecting a new vendor in 2015. And because of that, we elected to go with a separate high-risk area other than the examination process. Since, in order to give time to the new contractor, time to implement their processes and procedures and develop a history.
But we didn't change purveyors because of examination results to do it. No. But walk me through the process of that chart on number 2.
Okay, yes, sir.
See if I can understand it.
Because of, well, there are 8 areas that we provide a risk assessment for. Financial materiality, time since last audit or review, results of last audit or review, adequacy of staffing levels, policies and procedures, compliance with contracts, laws, and regulations, susceptibility of material theft or fraud, and the 8th one is existence of issues or concerns. For the examination process, they were rated high in financial materiality. It had been a while since they had been reviewed. I think it was in 2007.
What's the difference between the 36 and the 12 on education program monitoring? Why do they get 36 and the previous one on number 1 only got a 12?
You're asking between the complaint investigation process and the examination?
No. The education program monitoring. That got a 12 and examination got a 36. What triggered that?
It's really, I believe it was because of the amount of money that generated by the examination process, or where it affects the income more than the education monitoring.
So the 36 is the highest you can go?
It's the highest you can go.
So it's the highest risk. While number 1, education program monitoring, is 1/3 of the risk.
Yeah, for financial materiality it is. But in other areas it scored higher. And then overall it was rated higher. We rated it higher.
Let's go to number 4. Under adequacy of staffing level, when you compare 1 and 2, the education versus examination. Can you explain the difference between 24 and a 12?
On the examination process, the staff within the Real Estate Commission, although there was someone assigned to the examination processes, the level of effort is higher with the education program monitoring than the examination process, so it warranted a higher
level of effort.
The level of employees' level of effort. staffing.
Mr. Mixon, does that make sense?
Yes, sir. Mr. Arriaga, it does. If you look at that chart, just to get to those numbers, it's a simple factor. So for each of the 8 factors, there is a percentage that's listed above. That's the weighting factor. And then in each category, the risk factor scores, there's a little table at the bottom. So it's low, moderate, or high, 1, 2, or 3. And then depending on the risk factor that's placed there, it's multiplied times the percentage at the top to give you that number. So in this particular case, the examination process is handled primarily by a very experienced contract vendor who's been with us a long time. And of course, going forward, we have a new one that we've evaluated to be equally as reliable. But the internal process, the internal risk, the burden on internal staff of maintaining that program is actually transferred to that outside vendor, whereas the education program monitoring is done almost entirely, with the exception of the IDEC reviews, entirely by internal staff. So when you use the word burden, that absolutely makes sense, that it would be low risk from the burden side for examination and moderate on the education programming. We do have 2 openings right now in our education department where we're understaffed from recent retirements, but we're working hard to upgrade those and find replacement staff for those. In fact, Ms. Jackson was just at the Real Estate Teachers Association and did as I asked her to do, which was announce that we had openings in our education department. And I actually received a phone call while she was there, someone who was interested in one of those positions who has a significant education background. So we're very hopeful that those positions will be filled. And I know that's beyond what you asked.
Still trying to make sense, so please forgive me for walking through, but I think this is the next audit, I think I can follow up on how the transition happens from year to year. Thank you very much, Mr. Galindo.
You're welcome, sir. There are no other questions.
Are there any other questions for Mr. Galindo? Thank you.
Thank you.
So we return now to our agenda, to agenda item 9, where we seek general comments from visitors on non-agenda items, and I do have one person who has asked to speak on an, I'm sorry, did I skip something? You need a motion to approve the plan. Oh, we did? It's not on there. Well, before we do that, we need a motion to approve the plan that Mr. Galindo has presented. It's not in the package.
So moved. Second.
I have a motion and a second. All in favor say aye.
Aye.
And opposed, no. Motion carries. Thank you, Mr. Olmixon, for keeping us straight. Let's go back to the agenda. Mr. Harbuck, you've asked to speak at this moment in time, and you'll have 3 minutes.
Thank you for the great work that you all do. Very conscientious. It's a real pleasure to see all of the work that comes out of all your meetings and your efforts. Your conscientiousness is much appreciated. Just wanted to mention that in the ESAC and Inspector Committee meetings that occurred since your last meeting, a University of Texas law professor who's an expert in antitrust law did come in and just testified briefly, and he encouraged the committees to try to avoid adding expensive or unnecessary requirements as part of this process with the quadrennial review rules. I think it's chapter F and G. That's not on the agenda today, but you'll probably address it at some point in the future. And he just recommended that they, he stated that if the additional costs that might come from those sorts of requirements would ultimately be passed down to the Texas consumer, and if they were adopted in such a way. And although remember, this is not finalized at all, this is all just in discussion, and so he wasn't in any particular point at that time that if we have fewer providers, then we increase the cost for training, and then those added costs are typically affect those that can least afford it the most of the Texas consumers. So that's all I wanted to mention. Thank you.
Thank you, Mr. Harbark. Is there anyone else? Thank you. Anyone else here who wishes to speak on a non-agenda item? Anyone else? Going? Okay. Okay. It is now 10:55 a.m. The Commission will go into executive session to discuss pending litigation or obtain legal advice of counsel pursuant to Texas Government Code 551.071 and to discuss the personnel matter set out in Agenda Item 31 pursuant to Texas Government Code 551.074. We anticipate coming back to open session in approximately 45 minutes. 37. Okay, we're going to call the meeting back to order at 11:37 and take up Agenda Item 11. Is that presenting would be Ms. Lewis?
Good morning, Carrie Lewis, General Counsel. This is the Recovery Fund claims. The first item up is Recovery Fund 14-008, Schroeder versus Fleming.
Okay.
Madam Chair.
Yes, Commissioner Hensley.
I'd like to make a motion to authorize payment for actual damages. On reference number 14.008, authorized payment of actual damages of $4,575 plus interest, court cost, and reasonable attorney fees.
I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries.
The second case for consideration for action by the Commission is case number 13-025, Wheeler versus Dillard.
Commissioner Alley.
Madam Chairman, I'd like to recommend the authorization of payment of actual damages of $2,080 plus interest and court costs.
Have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Let me just point out for the record that Commissioner Jones actually recused himself from the vote on RF 14-008. Now, Ms. Lewis.
The third case for consideration is RF number 14-006, 915 Southwest 36th Street LLC versus San Antonio Smith Realty LLC.
Ms. Commissioner Justice.
Madam Chairman, regarding 14-006, I recommend that we authorize settlement on the best possible terms for actual damages that are supported by sufficient evidence, plus interest and reasonable attorney's fees.
A motion. Do I have a second?
Second.
All in favor say aye.
Aye.
Motion and opposed, no.
Nay. Madam Chair,
Yes, sir.
I want to go on record as saying that and this is just a personal reflection, I believe that the Recovery Fund is being abused by either plaintiffs and/or attorneys, and I find this situation occurring in this case, and I find it appalling.
Thank you, Commissioner Aga. The motion carries. Agenda item 12.
Agenda item 12 is discussion and possible action to adopt amendments to 22 TAC sections 535.62 and 535.64. The proposed amendments to these sections were published in the March 21st, 2014 issue of the Texas Register, and they add a new subsection F, which is a 30-hour core course with specific topics, subtopics, and units. And no comments were received on these proposed amendments, and staff recommends that the rules be adopted as published.
Do I have a motion?
Madam Chairman,
Commissioner Justice.
I move that staff is authorized on behalf of this commission to submit for adoption amendments to 22 TAC 535.62, acceptable courses of study, and 535.64, obtaining approval to offer a course, and forms adopted by reference without changes to the text as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption.
I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 13.
Discussion and possible action to adopt amendments to 22 TAC Section 535.212, Education and Experience Requirements for a License. The proposed amendments were published in the February 28, 2014 issue of the Texas Register. The amendments further clarify implementation of fieldwork requirements permitted by House Bill 2911. The amendments create two options for obtaining substitute experience going forward that emphasize the importance of hands-on training and keep a third option from the current rule in effect to allow providers time to develop courses that comply with the first two options. The adopted rule also reduces the number of hours required for classroom or alternative delivery interactive training modules to help control costs and promote hands-on training. There were several comments received on this rule, which came before the Inspector Advisory Committee at their meeting April 14th, and the Inspector Advisory Committee recommended that the amendments be adopted as published currently. Staff's recommendation would be to adopt the rule as published with a correction to a typographical error in subsection F, small Roman numeral 3, where the numbers were transposed from what the Commission actually approved for publication. In addition, although the proposed rule extends the time allowed for the third option from May 1st, 2014 to March 1st, 2015, this rule will take 20 days to become effective. Therefore, staff requests a directive from the Commission to continue to accept and give credit for this third option, the existing option today, permitting interactive training coursework during that 20-day gap period. So there'll be no loss of credit for someone who's caught in that middle time.
Understood. I actually have someone, Mr. Harbuck, who has written that he wants to speak on agenda item 13. You're done? Okay, thank you. Now seek a motion. Commissioner Jones?
Move that the staff is authorized on behalf of this commission to submit an adoption amendments to 22 TAC 535.212, Education Experience Requirements for a License, with the correction to the text that was previously published in the Texas Register as presented, along with any technical or non-substantive changes required for adoption. The Commission also directs staff to continue to accept and give credit for the third option, permitting interactive training coursework only during the 20-day gap period before the adopted amendments take effect. So moved.
Second.
A motion and a second. All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 14.
This is discussion and possible action to adopt amendments to 22 TAC Section 535.218 on continuing education. The proposed amendments were published in the February 28, 2014 issue of the Texas Register. The amendments increase the number of hours a licensee can take in only one subject area, adopt by reference a course approval form for the Texas Standards of Practice Legal Ethics Update course, and clarify that certain government entities and nationally recognized building organizations do not have to be a commission-approved provider for licensees to receive continuing education credit for approved courses offered by those entities. The amendments also incorporate a specific course outline for the Texas Standards of Practice Legal Ethics Update course to ensure consistency of subject matter covered by this mandatory continuing education course. The Commission received 3 comments on the proposed amendments. The 2 were from trade associations. These comments were considered by the Real Estate Inspector Advisory Committee in their meeting on April 14th, and the committee appreciates the comments but disagreed with the substance of the comments and recommended that the Commission adopt the amendments as originally published.
Madam Chairman.
Commissioner Hensley?
I move that the staff is authorized on behalf of this commission to submit for adoption amendments to TAC 22-535.218, continuing education, and the form adopted by reference without changes to the text as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption.
Have a motion, do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 15.
Good afternoon, Madam Chair. Kristen Warman, Deputy General Counsel, on behalf of the Commission to discuss Agenda Item 15. This item is to adopt amendments to 22 TAC, Section 535.223, the Standard Inspection Report Form. The proposed amendments to this rule was published in the February 28, 2014 issue of the Texas Register. These amendments notify consumers that an inspector may include contractual terms or attach a service agreement or inspection contract to the standard form. They also clarify that an inspector may change the standard form as necessary to allocate additional space for comments in the additional information provided by inspector section. The amendments clarify that an inspector may also attach additional pages for comments and adopt by reference changes to the standard inspection form number 7-4, approved by the Commission for use in reporting inspection results. There were no comments received on the amendments as proposed, and staff recommends the Commission adopt the rule as published with the non-substantive changes made to the form as presented. We further recommend that the form be made available for voluntary use upon adoption and required for mandatory use as of September 1, 2014.
Thank you, Commissioner Jones.
Madam Chair, move that the staff is authorized on behalf of this commission to submit for adoption amendments to TAC 22-535.223, Standard Inspection Report Form for voluntary use as soon as available, but mandatory use after September the 1st, 2014, without changes to the text as previously published in the Texas Register, with non-substantive changes made to the form and adopted by reference as presented by staff, along with any technical or non-substantive changes required for adoption.
Second.
Second.
I have a motion and a second. All in favor say aye.
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 And opposed, no. Motion carries. Agenda item 16.
Discussion to adopt to adopt amendments to 22 TAC Section 535.231, Standards of Practice, Minimum Inspection Requirements for Plumbing System. These amendments were published in the Texas Register on February 28, 2014. These particular amendments correct parts of subsection A, which were misnumbered, and correct the interpretation of that section, which inadvertently required action that was not required, resulting in a misunderstanding of the rule. No comments were received on the amendments as proposed, and staff recommends adoption as published in the Texas Register.
Commissioner Alley.
Madam Chairman, move that the staff is authorized on behalf of the Commission to submit for adoption amendments to TAC 22-535.231, Standards of Practice, Minimum Inspection Requirements for Plumbing Systems, without changes to the text as previously published in the Texas Registry, except for any technical or non-substantive changes required for adoption.
I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 17.
Carrie Lewis, General Counsel. This is discussion and possible action to adopt amendments to 22 TAC Chapter 537 for the listed contract forms, which are adopted by reference to this rule. Madam Chair, would you like me to take the existing forms as a group separate from the new form that's proposed?
Yes.
Okay, so we would be looking at 537.20 regarding the Form 9-10 unimproved property contract, 537.28 regarding form number 20-11, 1 to 4 family residential contract resale. Rule number 537.30, which in regards to TREC form number 23-12, new home contract incomplete construction. Section 537.31 regarding TREC form number 24-12, new home contract completed construction. Section 537.32, TREC form number 25-9, farm and ranch contract. Section 537.37, TREC form 30-10, residential condominium contract. These proposed amendments were published in November 29, 2013, issue of the Texas Register, and the rules are, there are no changes to the text. However, there have been some non-substantive changes made to the amendments listed on the forms. This is the second time these forms have been before you. They were sent back in February, so you will note that you had 2 sets of comments, previous comments and new comments. The changes, the most recent changes made since the last broker-lawyer committee meeting in April were put in your documents in green, and that was in your materials, just so it doesn't get too confusing. But when these are adopted, all of the changes, red, green, and blue, will be what goes forward in the new forms, just so that's not confusing. There were many different comments received both times. These were outlined in your materials, and unless anybody has any specific questions on them, I will not go through all of them.
Are there any specific questions for Ms. Lewis on these contract forms?
Madam Chair?
Yes, sir. Commissioner Arriaga.
I move that the staff authorize the 7.
Wait a minute, we have a speaker,
6
right? We can make the motion and then hear from a speaker.
You can make the motion and then...
Okay, let's go ahead and make the motion and take a second, and then we'll hear from a speaker.
I move that we authorize 6 forms on behalf of the Commission to submit for adoption amendments to TAC 22, Section 537.20, Standard Contract Form, track number 9-7, unimproved property contract. Section 537.28, Standard Contract Form, track 20-11, which is the 1 to 4 family residential contract for resale. Section 537.30, Standard Contract Form, track number 23-12, which is the new contract form, incomplete construction. Section 537.31, Standard Contract Form number 24-12, the new home contract, complete construction. Section 537.32, Standard Contract Form, track number 25-6, which is the farm and ranch contract. Section 537.37, Standard Contract Form, 30-10, residential condominium contract. As previously published in the Texas Register with non-substantive changes made to the forms adopted by reference of staff, presented by staff, along with any technical non-substantive changes required for adoption. The form adopted in reference will be available for voluntary use until June 1st of 2014, when the use of forms become mandatory.
Commissioner Arriaga, I just want to make sure that you said the 537.20 Standard Contract Form, track number 9-10, and then I wasn't sure I heard you right. I believe the farm and ranch contract is 25-9. Is that correct? Is that what you meant to say or said?
Farm and ranch?
Yeah, you gave the wrong reference number. I was just correcting it, that's all.
Oh, gosh.
So I need a second.
Second.
Now do I have a second?
Second.
Now, before we vote, I have a speaker, Aaron Day from Texas Land Title Company Association, has 3 minutes to talk.
Good morning, Commissioners. My name is Aaron Day. I'm with the Texas Land Title Association, and I want to thank you for this opportunity. I want to thank you for your service as well. We just learned about the changes to the contract that took place, all the contracts actually, but I'll speak specifically to the residential 1 to 4 family contract dealing with Section 6 Title Policy and Survey A8, or A8. Now, the changes that took place at the Broker-Lawyer Committee actually proved to be quite substantive, and we're concerned that they're going to have substantive impacts in the marketplace. And we just learned of those changes late last week. As soon as they were posted on the website, which they were posted last week, and also through word of mouth as it started to matriculate out through the community. And there was a great deal of concern that we haven't had an opportunity to seek very much input within our stakeholder group, nor I don't think the public has probably had very many opportunities. They look very straightforward. They look like simple changes, so they look very non-substantive. But as I've approached experts that deal with transactions day to day, they have some very real concerns that they'll have a substantive impact. So my request this morning is that you do not adopt the motion and that you do not adopt at least this portion of the proposed changes. We're completely okay with all the other changes. We would request that you just keep this section of the contract unchanged for this cycle and this decision today. Some of the concerns that have been raised have to do with unintended consequences and the way parties behave during the transaction, and the fact that you're physically changing the TREC form if the buyer were to change their mind at the closing table after learning more about the opportunity to purchase this additional coverage. And if that happens, we don't know exactly how that's going to impact the transaction vis-a-vis the new CFPB changes and the new changes to the settlement disclosure forms. There's a lot more rules coming down the pike, and as a result of that, that impacts closings. And so if this upsets the transaction, we may find further delays in closing and further complications resulting. And so my request to you this morning is very, very simple. It's that you not make this change this morning, that you wait and allow for more stakeholder and potentially consumer input as well, and allow us to get a chance to digest this, and we can come back with some comments for you and some recommendations as well.
Thank you for your time. Did you have a question for him?
Which form is that again?
It's all, well, most all the contracts that were presented, and I have before me the unimproved property contract. It's section 6A8, and it's also, I believe, the same section on the residential.
This is the same matter that has been debated in broker-lawyer for about 9 months, and Commissioner Arriaga.
And unfortunately, I understand that we were observing that debate, and we really didn't have a strong opinion. Our understanding at the beginning of this is that the initiative to make a change to the contract form was to encourage the adoption, more consumers to adopt this or elect this policy coverage, and we were okay with that. But then as it resulted from the Broker-Lawyer Committee, it looks like it will actually have the opposite effect and potentially other effects in terms of how the transaction takes place.
Mr. Dave, what's your role with the association, Title Association?
I'm the Director of Governmental Relations. Yes. And so I'm not a practitioner, but I'm the information gatherer and the feedback gatherer, and we, having learned about this particular change, which was not reflected in the minutes from the Broker-Lawyer Committee, unfortunately, and also we just became aware of it as our memberships became aware of it when it was posted last week on the website.
Thank you, Mr. Day.
Can I conclude from what I think I heard you say is that TLTA's concern is that the coverage will be deleted?
Yes, sir. We think this as written, well, we don't think anything officially yet. We haven't had an opportunity to get our arms around it. Some feedback I've received from some of my members is that this will have the impact of discouraging adoption of or electing this coverage.
Why?
Because what happens is folks look at it and say, well, that's just another fee. I don't have time to understand this. This has already been an overwhelming process, and so I'm going to elect not to do this. Or I hear I can push it off onto the seller. Perhaps I'll do that. And that creates more problems down the line. The folks that have the early feedback is that this means the most feedback I've received at this point is that indeed it will discourage parties to elect to have this coverage.
And your feedback's coming from your members?
Correct. Yes, sir. Folks, closers, folks that have witnessed these transactions on a daily basis. Yes, sir.
Thank you.
Madam Chairman, just sort of as a follow-up, this would be in place when the contract was negotiated. And what I hear you saying is you think we're going to run into things at a closing table on it?
Yes, ma'am. Yes, my understanding of how this works, and again, I'm not a practitioner, I'm just the information gatherer, and I can't speak with exactly how it's going to happen. I can't present to you this morning a consensus view because this just became an issue for us late last week, and I've been gathering the information, but the feedback that I've gathered thus far is that what will happen is that folks will say no at the beginning, and then at the closing table, they might be persuaded to say yes. And this contract is not as flexible as the existing contract in the status quo. If you weren't to change anything today, they would have the opportunity to make that election without it impacting this contract. If they make that election at the closing table because they say, well, what was this again? And they hear it from maybe someone from the title industry, and they're more persuaded that because they've learned more information about it, perhaps they at that point decide they want that coverage, and that extra coverage may affect their QM, it may affect the new RESPA, I should say the new CFPB rules that require a new waiting period before you close, perhaps.
Okay, Commissioner Jones, let's wind this down.
Would you be surprised to hear that in the old contract, the only change I see, material change, is who pays for it? That language actually exists in the existing contracts.
It may have the exception amended to read. So the non-determinative may allows for some flexibility at the closing table without impacting the contract.
See, the difference, though, in what I see is who pays for it. This one says the buyer at buyer's expense. This one says buyer or seller.
Yes, sir. However, it actually impacts two things. It decides two things. One, the decision, and two, who pays.
So it gives the consumer two choices.
It gives the consumer two choices at the front and precludes their opportunity to change their mind, potentially. So it takes away an opportunity for the consumer. Now, the consumer can change their mind, but they may have to not close that afternoon and wait another 3 days once the new CFPB rules come into effect. And they may impact their loan as well.
Okay, thank you, Mr. Day.
Thank you very much.
Ms. Lewis, did you want to say anything else?
I just want to make sure everybody's clear that if you'll notice, it's in red and blue ink. That means that was what was when we reproposed these in October. That's what was published in the Texas Register in November. So they've been out there since November.
That's what I thought.
Okay. No negative feedback?
No feedback from anyone else on this issue.
Actually, didn't the TAR Trade Association one that asked for the choice of who pays?
Correct.
We did get feedback
but
on
that was back in
that
October,
was
right? That was
prior to
prior to
November.
Mm-hmm.
Yeah, okay. So we have a motion on the table to approve the 6 contracts, and we have that motion does not include the mutual termination form, which we have not discussed at this moment. All in favor say aye.
Aye.
Aye. And opposed, no. Motion carries. Do you want to talk about the mutual termination form?
It's a new form that's been proposed. It's gone back and forth a couple times to broker lawyer from the commission. It's been a debated form, receiving comments probably at both different times that we've had this before the broker lawyer committee. So in its current form, what's being proposed is less than what was published, in that it takes out the option, the second option in the form, and leaves only the ability to release, mutually terminate and release the earnest money as directed on this form, and it adds a slight change to the consult the attorney. But the releasing without a release, terminating without a release of earnest money, that option was taken off the table as it was seen as too confusing.
Let me ask you a couple of scenarios. We have several choices if we want to take action on this form. One would be to just move it forward. Another would be to not move it forward and send it back to the broker lawyer committee with some comments. And the other is no action at all. Is that correct?
That's correct. If you take no action today, or even if you send it back, it would have to be reproposed because we're going to be past
Either
our
way.
6 months. Either way, it's going to have to be reproposed if it comes back in this form or another form, if you take no action
What is
on
the
it.
gentler thing to do to the Broker Lawyer Committee?
I don't really think it matters.
Okay.
They
What do you wanna
understand
do,
how it
John?
works.
Can I throw a fourth question in there? Can we make a change to this form without sending it back?
You cannot.
The title, that's the only thing that's,
Unfortunately, the way the statute is, it says the Broker Lawyer Committee shall
Okay.
then
propose the
I
form.
would like to move we send this form back to the Broker Lawyer Committee with a recommendation of altering the title, the way the form is styled, with proposed elimination of the word mutual. And in a real world, I'd like to see the word release of earnest money precede termination of contract.
I second that.
Well, I have a motion and a second. Is everybody on the commission clear that the proposal was to send it back with the recommendation to call this form release of earnest money and termination of contract?
Can I suggest that this form exists in other venues? The TDI people have them, the realtors have a form that does this. I don't sense the urgency here.
So that was the motion. Do I have a second? I did have a second from Commissioner Arriaga. Everybody understand the motion? All in favor, say aye.
Aye.
And opposed, no. Motion carries. Agenda item 18.
It's a big one.
Agenda item 18 is discussion and possible action to adopt amendments to 22 TAC Chapter 531, Canons of Professional Ethics and Conduct, and includes Section 531.1, 531.2, 531.8, and 531.19. All of these proposed amendments were published in the March 7th issue of the Texas Register and come following a comprehensive rule review. No comments were received on the proposed amendments, and staff recommends adoption as published.
Commissioner Hensley?
Madam Chair, I recommend that we move the staff to authorize on behalf of the Commission to submit for adoption amendments to TAC 22531.1, Fidelity 531.2, Integrity 531.8, Consumer Information and 531.19, Discriminatory Practices, without changes to the text as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption.
I have a motion. Do I have a second?
Second.
I have a second. All in favor, say aye.
Aye.
And opposed, no. Motion carries. Agenda item 19.
Discussion and possible action to adopt amendments to 22 TAC 533 Practice and Procedures. And it's a whole list of rules that we've got set out there. I won't name them all at this point. I would like to point out that these were all published in the March 7th issue of the Texas Register, and for the most part clarify terminology, correct grammatical errors, as a restructuring of the alternative dispute resolution section, and makes a few other clarifications. No comments were received from the public on the proposed amendments. However, after further review, our enforcement staff requested additional revisions to establish that the calculation of timeframes for replying to notices are from the date sent, and to add language that notices may also be sent by email for evidence of actual knowledge. So based on that, I would recommend that the staff recommends that the rules be adopted as published, except for sections 533.3 and 533.4, which staff recommends be reproposed with additional substantive changes later on in the meeting today.
Okay.
Madam Chairman, I move that the staff is authorized on behalf of the Commission to submit for adoption amendments to TAC 22-533.1, definitions 533.2, purpose and scope 533.5, the subjunctive hearing records 533.6, filing of exceptions and replies 533.7, proposals for decisions 533.8, and final orders, motions for rehearing and emergency orders 533.20. Informal proceedings, 533.30, ADR 533.31, referral of contested matters for ADR 533.33, qualifications of media at 533.34, commencement of ADR 533.35 stipulations, 533.36 agreements, and 533.40 negotiated rulemakings without changes to the text as previously published in the Texas Registry, except for any technical or non-substantive changes required for adoption.
Motion to have a second.
Second.
And a second, all in favor say aye.
Aye.
And opposed, no. Motion carries.
Agenda item 20.
Yes.
Discussion and possible action to adopt amendments to 22 TAC Chapter 534 General Administration. And again, these amendments were published in the March 7th issue of the Texas Register and were made following a comprehensive rule review of this chapter to better reflect current TREC procedures and simplify and clarify where needed. No comments were received on the amendments as proposed, and staff recommends adoption as published.
Mr. Justice.
Madam Chairman, move that staff is authorized on behalf of the Commission to submit for adoption amendments to 22 TAC 534.1, changes for charges for copies of public records, 534.2, processing fees for dishonored payments, 534.3, employee training and education, 534.4, historically underutilized businesses program, 534.5, bid opening and tabulation, 534.6, negotiation and mediation of certain contract disputes, and 534.7, vendor protest procedures, without changes to the text as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption.
Have a motion to have a second.
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 21.
We are now on to our proposed amendments. This is discussion and possible action to propose amendments to 22 TAC Chapter 533 for the reproposal of 533.3, filing and notice, 533.4, failure to answer, failure to attend, hearing and default, and a new section, 533.9, computation of time. These are, as we said, bringing forward 533.3 and 4 from what was previously proposed, but modified to establish that the that notice is the time for calculating notice is from the time it was sent, not from the time it was received. The new section 533.9 sets out criteria used to calculate time for sending or receiving any required notice to clarify and for consistency in calculating dates. There is one change from what was sent in your materials. If you'll look on page 284, where it says, or email address of record with the commission, that just for consistency, staff would like to change the language to be or email address as shown in the commission's records, since that's what we have in other parts of our rules. So with that change to text, staff would recommend that these rules be published in the Texas Register for comment as presented.
Commissioner Arriaga.
Madam Chair, I move that the staff is authorized on behalf of this commission to submit the proposed amendments to 22 TAC Section 533.3, filing of notices, Section 533.4, failure to answer, failure to attend, hearing, and default, and the new 533.9, computation of time as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment, with the changes pointed out by the counselor.
Have a motion to have a second.
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 22.
Discussion and possible action to propose amendments to 22 TAC Section 535.146, failure to properly account for money commingling. that actually this proposed amendment is a compilation of 3 other rules, which we will then recommend be repealed, and that's Section 535.146 and Sections 535.159 and Sections 535.160. The new language is in your materials. The new title would be Maintaining Trust Money and would apply to all trust funds held by a broker. I believe you are all handed out an extra sheet this morning that's got some green language on it, and that's some additional revisions to the language that staff would like you to consider before proposing it. Under subsection C3B, just clarifying that we're talking about the money, not the account, and actually I got some comments that it was, trying to figure out who the equitable owner was might be a little more difficult. Even though that language is in our existing rule, we thought it would be more clear just to say that unless otherwise provided for by an agreement signed by a party depositing the money with the broker, any interest earned on the money must be distributed to any parties to whom the money is dispersed. So if you don't have an agreement, whoever gets the security deposit or other escrow money or whatever it is will get the interest on it unless there's an agreement to the contrary. The other change is, again, just a clarification in subsection 5, that if a broker acquires ownership of trust money held in a trust account, including entitlement to, we change it to be compensation, which is a broader category than just real estate commission. So again, that's just an easier term and more clear, since compensation could be more than just a real estate commission. And then the last one in 7, I want to give a little bit of explanation on this because we have several different current rules that speak to who can a broker authorize to sign or be a signatory on a trust account. We have our current rule 535.146, which says that a broker may designate a salesperson to be an authorized signatory on a trust account. We have our broker responsibility rule, which says that a broker may designate another person as an authorized signatory on an account. And then we have, after both of those rules were put into place, we have the statutory provision that came into place in 2011 about a property manager who controls the deposit or acceptance of rent. They must be licensed. So that has been interpreted in rule, I think it's 160. That's not 160. It's in the rule we describe that they must be licensed if they control or deposit they control the acceptance or deposit of rent if they can withdraw the money. So that person must be licensed. It doesn't speak exactly to a trust account, but it creates some confusion. So in combining all of those rules and trying to give clarity to consumers and to our license holders, we are recommending that the Commission use the language set out in 7, which says a broker, with the blue and the green, says a broker may only authorize another license holder to withdraw or transfer from any trust account, but the broker remains responsible and accountable for all trust money. That's existing in our law today. It's just clarifying which one.
Thank you. Is it proper then to do 22 and then repeal the others? We don't repeal and then
Right,
pass?
and these are just being proposed.
Proposed.
So we would propose this one, it would go out for publication and comment,
And propose
we would
repealing.
propose a repeal. And then
Okay.
when we adopt this, the other would be adopted.
Trying to get the order straight. Commissioner Jones, did you have a motion?
A comment was to thank you and the staff for this hard work. I know there was a lot of moving parts to this, and I think you did a very admirable job of putting all this together. Move that the staff is authorized on behalf of this commission to submit proposed changes to new Rule 22, TAC 535-146, maintaining the trust money as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Have a motion and a second. All in favor say aye.
Aye.
Any opposed, no. Motion carries. Agenda item 23.
Discussion and possible action to propose repeal of 22 TAC 535, Sections 146, failure to properly account for money commingling, Sections 535.159, failure to properly deposit escrows monies, and Section 535.160, failure to properly disperse escrow money. This is the companion to what you just proposed.
Okay. Commissioner Hensley.
Madam Chair, move that the staff is authorized on behalf of this commission to submit the proposed repeal of 22 TAC 535.146, failure to properly account for money, commingling, 535.159, failing to properly deposit escrow monies, and 535.160, failing to properly disperse escrow money, as presented, along with any technical or non-substantive changes required for the proposed repeal to the Texas Register for publication and public comment.
Second.
Have a motion and a second. All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 24.
Discussion and possible action to propose amendments to 22 TAC Chapter 541, .1 Criminal Offense Guidelines and 541.2 Criminal History Evaluation Letters. The proposed amendments are made following a comprehensive rule review for this chapter to better reflect current TREC procedures and to simplify and clarify where needed. The proposed amendments to Section 541.1 clarify the scope of the bribery offense, add offenses involving thefts and felonies involving the manufacture, delivery, or intent to deliver controlled substances. And TREC considers when determining a person's ability to perform the duties and responsibilities of persons licensed by TREC, and it removes language that is duplicative of the Texas Criminal Code and adds clarity and consistency of terminology throughout the rules, and staff recommends proposing the amendments as presented.
Commissioner Alley.
Madam Chairman, I move that the staff is authorized on behalf of the Commission to submit the proposed amendments to 22 TAC 541.1 Criminal Offenses Guidelines and 541.2 Criminal History Evaluation Letters as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Motion to a second.
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 25.
Discussion and possible action to propose amendments to 22 TAC Chapter 537 to propose amendments to two TREC forms. One is TREC number 36-7, addendum for property subject to mandatory membership in an owners association. The other is form number 44-1, addendum for reservation of oil and gas and other minerals. These two form amendments are being brought forward by the Broker Lawyer Committee, and one simply adds a reference in paragraph C to paragraph E. That's for the mandatory membership. So that's clear that that fee is included in that paragraph C. And then the second amendment to the reservation of oil and gas and other minerals comes after many comments that the Broker Lawyer Committee has received from practitioners in that field. And it's does away with the definition of mineral interest because it's not a complete definition and it could be confusing according to oil and gas lawyers, and sets out the percentages in terms of fraction. And basically those were the major changes there. And also makes it clear that it doesn't apply to farm and ranch contract forms.
Okay. And the staff recommends
that they be adopted that they be presented
proposed
for publication.
Commissioner Arriaga.
Madam Chair, I move that the staff is authorized on behalf of the Commission to submit the proposed amendments to 22 TAC Section 537.43, Standard Contract Form of TREC number 36-7, addendum for property subject to mandatory membership in the owners in an owners association, and Section 537.51 Standard Contract Form Track 44-1 Addendum for reservation of oil, gas, and other minerals, and the forms adopted by references as presented by staff, along with any technical and non-substantive changes required for proposal to the Texas Register for publication and public comment.
I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 26.
Discussion and possible action to close the review of Chapter 531, 533, and 534. Staff has completed review of these chapters and recommends closing the review of rules as presented.
Commissioner Jones?
Move that the staff is authorized on behalf of this commission is to close the rule review of 22 TAC Chapter 531, Canons of Professional Ethics and Conduct, Chapter 533, Practice and Procedure, and Chapter 534, General Administration.
Second.
I have a motion and a second. All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 27.
Discussion and possible action to propose the review of 22 TAC Chapters 537, 539, and 543. These will be the last three chapters that will be reviewed under our quadrennial rule review.
Commissioner Justice?
Madam Chairman, I move that staff is authorized on behalf of this commission to submit the proposed chapters for rule review, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and for public comment.
I have a motion. Do I have a second?
Second.
Second.
I have a motion and a second. All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 28. Commissioners, a couple of things here. I would request that the staff spend a little time investigating and bringing a recommendation for perhaps a legislative change on how to protect our fund from abuses while we may still be serving the consumer. Perhaps we would look for a better definition of the oxymoron reasonable attorney's fees in that change. And also going to recommend that the executive committee meet just before our August meeting and look at where we are on the recovery fund. The current rule about the recovery fund is that we need to whenever the account balance goes below $1 million, we need to take some action to get it up to $1.7 million. And to exceed, if it ever exceeds $3.5 million, that money goes back to the legislature. And we're at 1.8 right now. We have sort of held aside something like $600 and something thousand that might be paid out. So by our August meeting, we could be, if all of that's paid out, looking at something real, getting close to $1 million. So we might need to make a recommendation for action. So if y'all are all good with that, my recommendation is that the executive committee look at this and bring a recommendation to you at our August meeting after an executive session to review what kind of call we might need to make or not make in that regard, depending on what's happened between now and then. Anybody have any questions about that? Okay. Then I would, we've already taken action on agenda item 29 earlier in our agenda, so we would look at agenda item 30, which we're on page 329 of 358, and I see Mr. Olmixon standing up. Sounds like he's going to talk. Is that okay with you? Might as well be.
Commissioners, Doug Olmixon, Administrator. For agenda item 30, I've handed out to you a interim progress report on the fiscal year 15 through 19 strategic plan. And I just want to hit a few of the highlights there. In prior years at the spring meeting, staff would be presenting a draft version of the strategic plan for your consideration with a recommendation that any comments from members or key stakeholders be provided back to the staff and to the chair within a couple of weeks so that we could meet the June filing deadline with state leadership. The good news this year is that compressed time frame does not apply. As an SDSI agency, we're not required to complete the plan nor to file it with leadership. However, staff recommends that the agency continue to do both, but on a schedule that more effectively maximizes consideration of the potential responses to the issues by a broader set of stakeholders. So we completed the 6 listening tour meetings in March all across the state, and received also over 100 responses to the online survey with the questions you approved at your last meeting. Staff met and analyzed the results, and I've listed for you the key issues that were raised and commented upon by the participants, and I'll just give you the general category is a widely recognized need for better education content, better presentations, and increased accountability. And then there are about 9 or 10 specific recommendations there, either for action or for consideration. In addition, when the staff met, there were various clarifications and equitable considerations that were raised that are desirable to enhance the operation of the agency and assist in the mission of consumer protection. And there's another half dozen issues listed there. These and related concepts will be shared with the appropriate committees of the Commission and working groups of the Commission and of the Board, as well as this is a joint strategic plan, and developed into a final recommended strategic plan to be presented for your approval at the summer meetings in August, and then filing with state leadership prior to September 1st at the start of the new fiscal year. This timing works much more effectively with the approved calendar of rule review progress and the appropriate development of the proposed FY15 budget to reflect any initiatives represented in the strategic plan. If you have any questions about any of the specific items that are listed there, I'm happy to try to address them.
Mr. Olmixon, if a commissioner wanted to come down and read some of the surveys, would that be possible?
Absolutely. In fact, we could forward the survey results. We have them tabulated.
A compilation.
I would have to give you a warning that there are several very direct and indiscreet and politically incorrect remarks that are made in a few of them. So just not to shock anyone opening it up and...
Sure, we would all be shocked.
Yes.
Madam Chairman.
Yes, ma'am.
I just would like to make a comment that I was very impressed, and of course have been to these meetings before, but the one I went to was extremely well attended, and more importantly, I thought everyone was very involved. Lots of questions asked, lots of input. So I commend you and all the staff here who have managed to get out there and get all those discussions going. I was really impressed.
Thank you, Commissioner Justice. Does anybody have any interest in reading the compilation but me?
No, ma'am.
No. Then maybe just to me.
I'll be happy
and
to
I'll be
forward
shocked.
them to you.
I'll be shocked all
Chair.
by myself. How's that? Commissioner Hensley wants it.
Commissioner Hensley would like them as well. Okay.
Thank you.
You're welcome.
Okay. Agenda item 31, discussion of possible action regarding the salary level of the administrator. Commissioner Jones, could we have some kind of motion from executive committee? Would you be willing to do that?
Executive committee met this morning, and I'd like to bring forth a motion to increase or change the administrator's salary level on an annual basis to $141,000.
Second.
I have a motion and a second. And this will also take us to a once-a-year review time. Is that correct? Okay. All in favor say aye.
Aye.
And opposed, no. Motion carries. Oh, yeah, effective date. What do you think? I'm sorry. Did you want to make an effective date in there?
Effective next pay cycle.
Next pay. Is everyone?
Put a date.
Put a date. May the 1st.
Can I make
May
a
1st.
recommendation?
May
What,
1st.
sir?
It was supposed to be in after 6 months, and I think we're past the time.
We are.
Okay.
Whenever
So we go
it's-
back and calculate the actual date from 6 months when we said we were going to do it? No. May the 1st. May the 1st, all right? May the 1st, 2014. Okay. Picky. Agenda item 32. It's a good thing we got that in first, right?
Yeah.
Okay, Commissioners, you have in your materials handed out, it was handed out prior to the meeting, the proposed budget for FY15. So this is the first draft. As Commissioner Hensley said, she and Commissioner Alley grilled me mercilessly this morning on the details of the budget. No, actually, they were very inquisitive, but asked very insightful questions and made a couple of recommendations that I think we should take into account. So I wanted to just go over a few of the assumptions that go into the proposed budget, and then happy to answer any questions that you might have. So
Mr.
if
Olmixon,
yes.
do we have this? Is this what was in the thing in the beginning? Hard copies?
No, it was in the.
This is different than what we had before?
We're going to make
some copies.
We're going to make more copies.
Okay, well, we'll look along and they can look along.
No, we got it. Yeah,
Okay, we got it, we got it. Okay.
You have theirs, you have yours now, you all.
Thank you.
I apologize.
I didn't have it too. I was like, am I the only person that didn't have it?
So that was my bad on the communication with staff.
Okay, nobody's mad.
Ms. Huerta asked me if she should bring copies, and I said yes, and was not directive enough to say
Chill out.
copies to the commission versus copies to the committee.
Next.
Okay. So, salaries and wages. This is, of course, the largest category on a budget every year. If you'll look at the kind of the highlighted column, which is the budget for 2015, that number includes a 2% cost of living or across the board adjustment to match what is happening at the state level so that we stay competitive. That was a legislative directed increase that will take place on September the 1st. In addition, I have asked for an additional 2% in that number. That's our recommendation to continue the reclassification and advancement of the staff toward meeting the median salary. So that's our long-term goal, is by 2020 to be at the median for each of the appropriate classified individuals. So we still have about 7 reclassifications I think we need to do over the next few years, and then advancing that towards the median in addition to matching the state requirement. Employee benefits, that category unfortunately includes something that we have no control over, and that is the health care costs for our retirees. And so that percentage approaches 30%. We will be breaking that number out so that we can calculate what the actual the percentage of other benefits is based on the base salary. Let's see, professional services, that includes our database and our website, and of course we will expend significant funds this year on developing our new website, and so we won't need as much next year for the development project. In the office rent category, you need to view office rent, and then the second line up from the bottom, the SWICAP, statewide cost allocation plan in conjunction. It looks like we only paid half of our rent, but actually our rent is offset in the lease by the cost of that is allocated to us under SWICAP. And so this year, that was a stunning 51% of our rent. So that's offset. So we've actually, we'll pay the dollars out, we'll just pay them in a different category. So it's approximately the same dollars if you combine those two together. We do believe that that will continue next year. We don't have any reason to believe that they'll change that allocation. They recapitalize the building and charge us depreciation under SWICAP, and so it offsets our rent. That's the good news. In many other categories, I'm happy to tell you that we continue efficiencies and don't need as much paper and postage and supplies and all of those kinds of things as we move, as our licensees continue to utilize our electronic services, our online services, and so that's a very good thing. The two categories that have gone up slightly are regard to travel and registrations and memberships. You'll see some there because all of those expenses are going up. And so on balance, we actually show on total expenses about $400,000 projected over last year's budget. That's the expense side. If you'll flip the page over and look at the revenue side, you'll see that we are projecting, for this fiscal year, we had projected $8.5 million in revenue. We believe that by the end of August, we will have collected $8.7 million in revenue. And so we'll be about $250,000 ahead of what was approved when we projected the budget at the beginning, or this time last year for the 2014 budget. And that's good news. We believe that for 2015, we'll collect about $8.9 million in total revenue. And so we're projecting just under about $471,000 operating in the black next year as a part of this proposed draft budget. Now, two things that were brought up by the Budget Committee that I think are worthy of discussion, or certainly sharing with you, is they asked us to very carefully go back and look at our compare our growth in both revenue and expenses to other Article 8 agencies, and that's two categories: the licensing agencies that are LAR driven, and then also those licensing agencies that are SDSI, and to be able to provide to them some comparison to make sure that we remain reasonable, and nothing that we do would shed or would require or would invite undue scrutiny. Okay, so that was number one, and I thought that was an excellent suggestion. The second one was that, as you may recall, in 2013, 11, 12, yes. So when we became SDSI, we asked our license holders at the time to approve a $5 per year increase in their fees, their renewal and application fees. And they graciously granted that to us and supported that in order to pay the $750,000 annual contribution to general revenue that we're required to as a part of our SDSI status. In FY13, at the end of that, so 11, 12, that's right. So we this commission approved a reduction in fee of $2, okay, and that actually began the process of returning those renewal fees, especially to the level that they were at before. So that was one of the commitments that the commission made to our license holders was, as soon as we can afford it, we will give you back that $10, basically over two-year license period. So one of the things that was suggested was to look at restructuring the fees on a revenue neutral basis, revenue neutral, so we collect the same amount of fees while reducing renewal fees by $3 per year. Okay, looking at that option, where could we otherwise increase fees to offset enough so that we collect the same amount of revenue, but are able to return or fulfill that commitment to return the fees on renewal to the previous level. Okay, and that's something that, so we'll run some various scenarios, bring them to the Budget Committee for them to look at and consider and make a recommendation to the full commission.
Okay.
Okay. The last item that I want to just comment on is the projection of cash balances. We have, as of this date, you can see all of the numbers there. With the total cash available, and then our projected revenue that we'll collect, and our projected expenses through the balance of FY14. Puts us with a projected cash balance of around 4.5 at the end of August 2014. And then if you add in the additional projected surplus for next year at the end of August of 2015, we project that we'll be close to $5 million. One of the things that we want to be very careful about doing is maximizing the investment return on our reserve cash. So this commission has established a policy that we should maintain liquidity with respect to up to 4 months worth of operating expenses. And we have just reached that threshold for absolute liquidity. It's just shy of $3 million. So we just crossed that threshold. And so we'll look at short-term investments for the difference between that required liquid cash and the other cash that we have on hand to maximize the return to the commission. Any questions?
We have questions of Mr. Olmixon?
So we'll continue to work on this budget. I assume you want
Do we want some kind of motion here?
some kind of approval
From
to
the Budget Committee?
continue ahead. But the budget will not be up for approval until August. So this is kind of a progress report. And then if there's any further directive from the entire commission, you've heard the suggestions that were made. We all have taken those under advisement from the Budget Committee. And so it's up to you if you want to direct us staff any more specifically.
Commissioner Arriaga has a question.
The 4-month reserves, how is that related to the rest of the agencies? I know we're a little bit different because we do not have the big umbrella they do, but is that standard?
Across the SDSI agencies, that is a very typical target for operating reserve.
And our monthly expenditures or income is about $700,000 a month, which is 8.5 divided by 12.
Not having a calculator in my head, I'm just going to go with that.
You said shy under $3 million.
Okay.
Yeah.
Okay.
Thank you.
So 4 months, right, 2.8 million. There we go.
Thank you.
I got you.
And the staff and the Budget Committee for watching our money and our people's money. Agenda item 33, Ms. Lewis, and I have a speaker on this in a moment.
Discussion and possible action to approve a new addendum for reverse mortgage financing approval form for voluntary use. The Broker Lawyer Committee recommends that the Commission approve this new form as a voluntary form available for use by licensee. Currently, neither paragraph 4 regarding financing in the contract forms nor the third-party financing addendum adequately addresses this type of financing, which is increasing in the marketplace. And I know that the Broker Laureate Committee will continue to look at this for future form. And so staff would recommend approving the form as presented.
Okay, now I have a speaker, Mike Hancock with Champions Real Estate School. I'll let you come and talk, 3 minutes.
Mike Hancock, Champion School of Real Estate. The need for this forum is pretty compelling right now, because at the school we're getting regular inquiries from loan officers and real estate licensees as to how to do one of these transactions. And we're aware that these transactions are going on right now. And of course the concern is what kind of wordsmithing might be going on to force the existing forms into a reverse mortgage type of transaction. So there is a demonstrated need for something to accommodate this type of loan.
So you speak in favor of
absolutely
moving this form as a voluntary use form?
Absolutely.
Okay, thank you, Mr. Hancock. Commissioner Arriaga, you want to speak?
I'd never seen anything like this before in my life, but I'm sure it's occurring. Real estate professionals were accused of being part of the real estate bubble because we made sure that we took our people looking for mortgages to the right mortgage company where we would make sure that we could close, so we'd make sure we get the commission. Thus, we created part of the problem that we have. I think this is going to be going in the same direction, so I recommend that we keep an eye on this, and if we can delay it as long as possible. I never want to be accused as a real estate professional that we promote financing that could be considered improper just to collect the commission. And I think that's where we're heading to. Thank you, Madam Chair.
Thank you, Commissioner Arriaga. Does anyone feel compelled to make a motion?
Madam Chair, I'll make a motion. I move that the commission approves the new form OP-N reverse mortgage financing addendum for use as submitted with any technical and non-substantive changes.
I have a motion. Do I have a second?
Second.
I have a second. All in favor say aye.
Aye.
And all opposed, no?
No.
Motion carries. Agenda item 34. Ms. Jackson.
Gwen Jackson, Director of Education and Licensing Services. Agenda item number 34 is discussion and possible action to approve new TREC application forms or revisions to current forms. And we have a list of several forms there, and I'd like to name the title of the form and provide a summary of each form as I go along, if that's okay with you.
That's fine.
The first form is the affidavit regarding substitute experience fieldwork requirement. And this form is to be used by inspector applicants who are unable to fulfill substitute fieldwork experience as set out in section 535.212 of the rules. Submission of this affidavit will allow the applicant to complete an approved classroom or alternative delivery interactive experience training module instead. B is the instructor application, inspector core, and ICE non-elective courses. This form includes requirements to teach the Texas Standards of Practice Legal Update course, as well as the ride-along inspection course. C is the inspection log. This form is an existing form that's being revised to include a checkbox for inspectors who submit a log for approval to teach the ride-along inspection course or the SOP Legal Ethics Update course. The form under D is the instructor application for Inspector Continuing Education elective courses, and this form will allow individuals to request approval to teach Inspector Continuing Education courses. E is the inspector course application. This form is to request the review and approval of inspector core courses. F is the alternative instructional methods reporting form. This form revises an existing MCE form to include inspectors so that they can also report credit for having completed an inspector alternative delivery course. And then G is the credit request for an out-of-state course. This form revises an existing MCE form to also include inspectors so that they can report credit for completing an out-of-state inspector course. And I believe H is a TREC complaint form that will be discussed later.
Actually, the commission member who had a concern about that form is not present, so we would recommend no action be taken on that.
Okay. And staff recommends to approve the forms as presented.
Okay. Commissioner Hensley, are you going to move this?
Okay. Which one are we taking out? I'm sorry.
The one that's got brackets around it. It's in brackets.
Madam Chair, I move that the commission approves new form INSA-0
Whatever.
affidavit regarding substitute experience field work requirement changes to INS-ED-INE-1 instructor application, inspector core, and ICE non-elective courses, REI-1-4 inspection log, and IAE-1 instructor application, ICE elective courses, new form, INS-DCA-0 inspector course application, and changes to MCE AIMRF-1 alternate instruction methods reporting form, MCE CROS-1 credit for an out-of-state course.
As submitted.
And
As submitted.
as submitted with any technical and non-substantive changes.
Second.
I have a motion and a second. All in favor say aye.
Aye.
And opposed, no. Motion carries. Thank you, Ms. Jackson. Agenda item 35. Do we have any possible future agenda items that we need to discuss? Okay. I would ask that if Christine Anderson is not going to be back at the next meeting, that she send pictures of Jackson so we can see him. That would be my future agenda item. Agenda item 36, discussion of possible action to schedule future meetings. I believe we have a meeting on August the 18th, most likely at 10 o'clock in the morning, and again on November the 17th. And staff has proposed February the 9th. February the 9th is the next meeting, 10 o'clock in the morning, 2015. Yes, sir.
And that is to coincide with the TAR
Right.
mid-year meeting,
Right.
winter meeting, or whatever they call it.
Whatever they call it, so that we're all here together, living happily ever after. Everybody good? Thank you so much for your time. All of you visitors, thanks for sitting through this fabulously exciting meeting. We appreciate your commitment to our industry. I appreciate all the commissioners. We are adjourned.